Today, my friends and I are going to present about the case of ROZILAWATI binti Haji BASIR versus Nationwide Express Holdings BERHAD and others. Before a meeting of members of a public company can be conducted, a notice must be sent to all members entitled to attend and vote at the meeting according to Section 316, subsection 2 of Companies Act 2016. The deadline for distributing this notice is at least 21 days or any longer period, and in any other case, 14 days prior to the meeting. However, the time period may be different depending on the constitution of the company. Furthermore, it is stated in Section 317 of Companies Act 2016 that the notice of the meeting must include the meeting's location, date, and time, as well as the general nature of the business of the meeting. It is important to note at this point that the Companies Act not mention about the distribution of an agenda as a requirement prior to a meeting.
Overview: the case of ROZILAWATI binti Haji BASIR versus Nationwide Express Holding BERHAD NEHB was held at the High Court on 18 August 2020 as an issue of company law or law of meetings. The specific particulars matters are not required to be included in the notice of director meeting. ROZILAWATI was a former director and managing director of Nationwide Express Holding BERHAD, the plaintiff in this case. NEHB is a public company listed on Bursa Malaysia main market. ROZILAWATI and the other director of Nationwide Express were notified of a board of director meeting scheduled on 30 May 2018 by way of a notice dated 27 April 2018 at which a resolution was passed to terminate ROZILAWATI employment as NEHB managing director. ROZILAWATI filed a lawsuit against NEHB and its board of directors, claiming that the board meeting and the director resolution of termination were invalid. ROZILAWATI claimed that the board meeting notice and agenda did not specify or indicate that her contract of employment, performance, or conduct as managing director will be addressed at the meeting, or that a decision will be made to terminate a contract of employment. She asked for a declaration that the board meeting was convened improperly and that the resolution passed at the meeting was invalid. Further, the NEHB Board of Directors did not deliberate or vote on the resolution before it was passed. ROZILAWATI's case was dismissed by High Court.
The decision is significant in two respects. Firstly, the High Court explained that there was no lawful prerequisites for a board meeting notice to contain the issues or specifics of the business to be executed at the meeting. Such a requirement was best practice. This is except if stated in the company's constitution. Secondly, the High Court explained that it isn't required for a deliberation or formal voting process related to subject matter to the topic before a resolution in relation to the said matter can be passed validly.
We talk about the brief facts. The following are the relevant facts in this case. First, Article 86 of the first respondent constitution was quite concerning the requirement for a particular details to be mentioned in the notice or agenda for the board meetings. Second, the notice of the board meeting gave to the director just alert the directors regarding the assembling of the board meeting and didn't contain further information. And third, the agenda for the board meeting issued subsequently determined different things to talk about, including to get matter arising and to execute other issues, yet made no notice of any proposal to examine the plaintiff's performance as managing director or to eliminate her from that position. ROZILAWATI filed a legal action against NEHB and its director to invalidate the board meeting and resolution for end and terminate on that premise. First, the board meeting notice didn't contain adequate information or specific of issue to be executed at the board meeting. Specifically, the likely termination of ROZILAWATI as the MD of NEHB was excluded from the board meeting notice and the agenda of the board meetings. Second, there was no deliberation or formal voting by the board of NEHB before the directors' resolution being passed.
I will talk about the decision of these cases. ROZILAWATI's claim was dismissed by the High Court, whereby the High Court found that the board meeting and the director's resolution for termination and termination notice were all valid. Netabalanje concluded that a notice of a director's meeting does not have to provide specific details of matters that are to be discussed or debated, as it is not a mandatory requirement, relying on the English Court of Appeal case of La Compagnie de Melville versus Whitley. The judge acknowledged that as a matter of good business practice, corporate transparency and fairness to the targeted individual, the notice or agenda should provide a heads up on what to expect at the meeting, so that the relevant parties are prepared to address the issues that are likely to arise at the board meeting. The court also looked at the case of Ling Hiu Hing and others versus Pembangunan Ladan Hasan, Sunan Berhad and others, which the High Court ruled that a notice convening a board meeting was invalid because it only stated that the meeting was to fix a date for the company's annual general meeting and did not state that it was also to appoint the defendant as chairman of the board. Following that, the defendant utilized his casting vote as chairman to dismiss the plaintiff from managing director position. In this case, the judge refused to adopt the decision in Ling Hiu Hing because it was made by a court of coordinating jurisdiction and did not reflect the correct legal position as stated in La Compagnie.
I will continue explaining the decision of the High Court. The High Court reasoned that items to be considered at a board meeting do not have to be included in the board meeting notice. The High Court ruled that a notice of a board meeting and agenda for the meeting are not required by law to give out the issue or particulars of the business to be discussed at the meeting, unless NEHB Constitution does not include such as requirement. The High Court also clarified that a careful or formal voting process on the subject matter in question is not required before a resolution on the subject matter can be passed validly. If such a legal requirement is imposed, Ong Chee Kwan JC explained the impracticalities. First, directors frequently convene emergency meetings on short notice to address a variety of business issues. It will impossible disseminate an agenda for each meeting that detail all of the topics to be discussed. Second, it is common for directors to move on to other topics after discussing the issue or the agenda. This extra issue will not have been mentioned in the notice or agenda for the board meeting. Third, matters that may be considered of crucial enough to be listed on the board meeting notice and agenda is subjective and it is easy for directors to disagree. Lastly, if directors are required by law to be notified in advance of important issues to be discussed at board meeting, this could lead to proliferation or litigation centered on the omission or inclusion of matter in the agenda. As a result, board meetings will be frequently disrupted.